The United States Supreme Court just released an opinion on the issue of location data from your cell phone. And it is a big case, but it doesn't have all the far-reaching implications that you might think, or at least it doesn't conclude the case in a way that you might think. So what did they do? In this video, we're going to talk about it. Hey, my name is Drew Page. I'm a criminal defense attorney and the owner of Tidewater Defenders, which is a law firm out of Norfolk, Virginia. I've tried multiple jury trials and bench trials, had motions to suppress. And so this Supreme Court case of Chathery versus United States is an important case to our particular field. In this case, the facts are that someone committed a robbery at a bank. They were demanding, I think, $100 and some thousand. And when they went to a credit union video, the police say that they saw the person had a cell phone on them when they were attempting to enter into the credit union. And so they, based on that and the location and time and place of the event, they reached out to Google. And Google, of course, is one of the largest companies and largest collectors of data. And one of the things that they collect is location data. And so what the police wanted to do is set a geofence or a perimeter around the place where the robbery took place. And while they did that, they were seeking certain information to find out if they can narrow down the number of cell phones within this particular time event, and then see if they could ultimately get the information about who the owners of the cell phones were. And of course, once they went through all their processes with their warrants and the searches that they did, they came up with one of the names of the robber. So this person, of course, once he was charged with robbery, his attorneys filed for a motion to suppress on the basis that it was an illegal search and that the warrant was invalid. And so the lower court said that the district court, which was the trial court, ruled and said, hey, look, this is definitely an unreasonable search. And basically the search was invalid and it shouldn't have happened. But because the officers had a good faith belief that it was legal, it qualified under the good faith exception to allow the search to take place and the warrant to be upheld and the information not to be suppressed. So you might think, well, that's odd, because if a court says that a search is invalid, why would they be able to still be able to use the stuff? And it's because they had a good faith, reasonable belief. This is a new issue that came before the court. And so the police will know going forward not to do this. But in this particular case, they had a good faith exception. Now, of course, the appellant appealed and was asking the Fourth Circuit Court of Appeals to take another look at this and say, this is a problem. Rather than even addressing the whole issue of whether it was a good faith exception, the Fourth Circuit said and ruled and held that actually it was not a search at all, because it involved a third-party locator. Google is a third party. And because the third party is able to have this information, if the police gets it from a third party, then it cannot be an unreasonable search. There's no reasonable expectation of privacy in your location because you're offering it to a third party. And so they affirmed the ultimate ruling of the district court. They did not agree about the good faith exception, but they agreed and affirmed on other grounds, saying that not only did the good faith exception was not an issue, but it wasn't even a search. And so then the appellant appealed to the U.S. Supreme Court. Justice Kagan wrote the plurality opinion here, and there were some concurring opinions and dissenting opinions, and you can read all of those. The bottom line is this: the U.S. Supreme Court, all they addressed was the issue of whether the attempt by the police to obtain location history data is a search. Is there a reasonable expectation of privacy in a location history search by law enforcement? That is it. They did not decide the issue of whether the warrant process was followed correctly, whether it was a valid warrant, whether there was probable cause, whether there was a statement of sufficient particularity. They didn't even address the issue of the good faith exception. They sent all of that back down to the Fourth Circuit, but they did reverse and stated that, yes, this was in fact a search. And so they have now punted it back to the Fourth Circuit to determine whether the warrant was valid, whether there was probable cause and particularity, or whether the police should be able to go forward on a good faith exception. All of those things are addressed for another day. But this opinion is solely on the issue of whether location history data is a search. And Justice Kagan and the remainder of those in the majority of this opinion determined that, yes, in fact, it is. And the reason is because cell phones in our society now are basically like a part of who we are. And we put a lot of our private information, information about our personal, political, family, religious beliefs, and all of these things are in our phones. And because we can't just use our phones just to make phone calls anymore. If we were going to use apps and things of that nature, we have to be able to put in personal identifying information. We put in pictures. We put in videos. We put in bank account numbers. Basically, everything we do in our lives is in our phones, and that's something that's in the realm of history relatively new. One of the statements that the Supreme Court has relied on is Riley versus California, I believe, where it says, if aliens were to come down from Mars, they would think that cell phones were actually part of our human anatomy. So, cell phones are something that are intimate to us, and we carry intimate details with us in these cell phones. And because of that, even though Google is a third party and these other third parties that we transact with for apps are third parties, we still, according to the U.S. Supreme Court, have a reasonable expectation of privacy. One of the reasons is because in order for us to use the apps, the advertisers, the businesses and all that basically say, if you want to have full function of these apps, you need to turn on your location history and your location data. So they make it basically a requirement of us to put in all of our location information in order for the apps to run efficiently and to run fully and functionally as we would want them to do. And because we don't have any choice in the matter of whether we use those apps or not, with the location history turned on or off, then the courts are saying we basically have to put in our private information. And because of that, we have a reasonable expectation of privacy in our cell phones and in our location data. Now, does that mean then that we are 100% shielded from the government in finding that information? Well, not necessarily, because as I mentioned, only the question of whether we have a reasonable expectation of privacy was addressed in this opinion. Whether the government can still get a warrant and go through the proper processes, determining probable cause, stating with particularity what they want out of the warrant. If they comply with that as a matter of law, then there's a possibility they still can get this location information and use it against you in a criminal case. But that has not been decided yet. This case only addressed the issue of the search. So what does that mean going forward? Well, if you have a case involving location data, and I've actually got a murder case pending right now that involves this issue, file the motions to suppress. Your attorneys hopefully will be filing the motions to suppress, and clearly at this point we will be able to argue that there is a search involved, and that the government is involved in a search. So then the question will be: Is the warrant valid? Was there probable cause to issue the warrant, and was it with sufficient particularity to make sure that it is only that information as is necessary in order to obtain the information from the warrant? And then even so, will the police have a good faith basis for believing what they're doing with the warrant is valid at this stage? We don't know the answers to those other things. We'll have to follow the Fourth Circuit Court of Appeals opinion on that. As that comes out, I will try to update you on that. But in the meantime, we know that geofencing location history data is a search under the Fourth Amendment and serves as a good faith basis for defendants to file motions to suppress in cell phone location data. So it will be interesting to see how many future cases we have on this issue. Obviously, the question of whether it is a search or not has now been resolved, at least with this court, which is interesting again because this has been perceived as a much more conservative court. And despite that fact, there were enough votes to sway even the conservatives to jump in on this. And the problem is, of course, they don't want their cell phones searched either, right? I mean, politicians don't want their cell phones searched. Judges don't want their cell phones searched. And so it's just natural for any political person to jump in on this. I'm surprised even that Alito, Thomas, and Barrett dissented from the opinion. But you know, they certainly have the right to do so as sitting justices. But it is a very personal issue when we're talking about searching phone data, and particularly location data, because we don't want to live in a surveillance state where the government is always watching and you're always having to, you know, wonder if, you know, who's watching you and all these things. And, you know, we have to use these apps to function. I mean, there are apps where you're able to, you know, make sure you're able to follow your family and your children around to make sure that they're safe, that they're where they're telling you that they're supposed to be. And you don't want to take what you're using to make sure your family unit is protected to be served on a platter to the government to be able to surveil everything that you and your family are doing. The government's not meant to do that. And so this is an important case when it comes to the issue of privacy and reasonable expectations. So it'll be something to follow as it develops. I'll try to make sure to post a video on it. And if you have any questions, please put them down in the comments. Please like this video. Thank you to all of those who have stayed on as subscribing to the channel. If you're new to the channel, please subscribe. And until next time, stay tuned.